The order of the court. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine SCAO form PC 602. SCAO for State Court Administrative Office, PC for Probate Court, form 602. We'd be happy to provide you this form if you need it free of charge. With all of these SCAO forms, they are created by statutes and court rules. In this particular case, there's a court rule 5.162. And again, as you navigate through the probate process, whether it's a deceased estate, trust administration, guardianship, conservatorship, whatever it may be, we strongly urge you to be working with a skilled, competent probate lawyer to understand the language, the court rules, the statutes, and what's going on. This particular form is not a form that people generally create from their home. It's generally issued from the court, or after a hearing, the court may want you to submit a court order following the hearing or proceedings. So it's kind of like a form that can be used in many different forms and functions. It's not a one-use form. And to understand general motion process or petition process, you file a petition with the court, a motion, you ask the court to do something, there's a hearing and notice, and then there's a hearing, and then the court makes a ruling. And as we say, the court speaks through its orders. The order of the court is what directs what is to occur. So it is this order form that's kind of like a catch-all order. Now with SCAO forms, this is a pre-printed form, so it has a lot of information already on it. But most of the time, an order is hand-drafted or computerized, and all of the terms that are ordered of the court are then typed out, and then there are rules relating to how that order gets entered or signed by the judge. So again, let's work our way through this particular order form to understand how generally these forms work. The top left corner is the county in which the probate matter is in. Top right corner is the case number, and then as identified by the red rectangle, it's an order. So there's something here that the court is directing and ordering something to occur. The top part in the matter of, it could be a deceased estate, guardianship, conservatorship, trust proceeding, the date of the hearing, and the judge. Pretty intuitive here. It says on petition filed. As I explained earlier, there's a petition, which is the request of the court, and then there's a finding of the court. So then now the court is going to identify what the court's findings are after that petition has been filed. 2, notice of hearing was given to or waived by all interested persons. Now, due process says that when there's a petition filed, notice has to follow, and there are rules around who the interested parties are under Court Rule MCR 5.125 and related court rules and statutes. And notice is required to be given to those people that are being affected by it. This is general rules of motion practice. Now, those notices can be waived by the people, or they can be given direct notice. So it can be waived through a written process where they say, you know what, I'm not particularly interested, or I stipulate or agree to the request that's being asked. And then there's a space here for the court to make findings. So findings could be that the court has taken an evidentiary hearing and made certain findings of facts. The bottom section is the order section. And again, there's not a lot of room here. So this form is typically used when the court is making a small ruling here. But if it's extensive, typically these are hand drafted. But here, it is ordered that. And typically the language is very direct. It is ordered that the petition is granted. It is ordered that, guardianship is terminated. Whatever it may be, that language is going to be very direct and very specific here. But it's not created by the individual filling this out. It's directed from the court. So the court is going to obviously make sure that the language that's contained there is reflective of the findings of the court and what the court is issuing the order as it relates to the hearing that just took place. In the bottom section, pretty straightforward. There's a judge's signature, and if there's an attorney that's created or prepared it, the attorney section would go there. So again, a form that's typically created by the court. Sometimes attorneys fill this out, or lay people fill this out following a hearing. If the court makes a ruling and people aren't prepared with an order right on the spot, this order form is like a kind of a universal form that can be used to provide what the court has just ordered. But again, it can also be fully written out and created following the rules relating to the entry of court orders. Again, with all probate-related issues, we strongly urge you to be working with a skilled, competent probate lawyer. At the Probate Pro, we are passionate about everything probate. If you have questions about this form or any probate or trust-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.